92 seconds. Not a speech, not an argument, not even a denial, just silence. 92 seconds where one of the most powerful officials in the United States sat under oath and refused to answer the simplest question imaginable. Is that your signature? And in that silence, everything changed. Because this wasn't just a question, it was a trap, carefully built over 14 months, backed by authenticated documents and triggered at the exact right moment. What looked like a routine congressional hearing quickly turned into something far more serious. The room was full, cameras were rolling, and nothing about the atmosphere suggested what was about to unfold. Then, without raising his voice or making any dramatic accusation, a congressman placed a single sheet of paper on the table. Not a binder, not a classified folder, just one page, a wire transfer, $847,000, and at the bottom, a signature. The strategy was simple but devastating. First, a harmless question. Do you personally review large financial transfers? The answer came confidently. Yes, as standard protocol. That answer locked everything in place. Then came the document, a federally authenticated wire transfer, complete with routing numbers, timestamps, and a destination account that had already been flagged internally as suspicious before the transfer was approved. That flag, according to internal records, had been reviewed and then removed with a short, chilling note, "Matter is classified." And now, sitting under oath, the same official who had just testified about reviewing such transfers was being asked to confirm whether the signature on that very document was hers. At that moment, the room understood the weight of what was happening. Because a signature on a wire transfer isn't just ink on paper, it's legal confirmation. It means the person signing has reviewed the transaction, approved it, and accepted responsibility for it. And in this case, it meant acknowledging knowledge of the amount, the destination, the suspicious activity flag, and the decision to remove that flag. But denying the signature would be just as damaging because the document had already been authenticated by independent forensic analysts. Either answer would create a contradiction with previous sworn testimony. One answer could suggest knowledge, the other could suggest fabrication. Both carried serious consequences. So, instead of answering, there was silence. Not a few seconds of hesitation, but a full 92 seconds, long enough for every person in the room to feel it, long enough for the tension to become unbearable. No movement, no explanation, no denial. Just the visible weight of a decision being made in real time. And then, finally, not even an answer, but a legal move. The Fifth Amendment, a constitutional right designed to prevent self-incrimination, invoked in response to a yes or no question about a signature. Legally, it's a protection, but in that moment, in that room, it became something else entirely. Because when someone refuses to confirm their own signature on a document their office produced, under oath the silence starts to speak louder than any words ever could. What made that moment even more powerful wasn't just the refusal, it was everything behind it. The document didn't appear by chance. It was the result of a long legal battle, a freedom of information request that was initially denied, an appeal that forced the release of records, and a critical omission in a privilege log that made the document legally obtainable. Every step was calculated, every piece of evidence was verified. By the time it reached the hearing room, it wasn't an allegation, it was a fact placed on the table. And instead of making accusations, the congressman let the document do the work. He didn't need to argue. He didn't need to raise his voice. He only needed one question. Because in high-stakes investigations, the most powerful moment isn't when someone is accused, it's when their own records put them in a position where every possible answer creates a problem. That's exactly what happened here. One statement contradicted another. One signature challenged prior testimony. And in the middle of it all was a single decision. Answer or refuse. The choice that followed, those 92 seconds and the eventual invocation of the Fifth Amendment, will likely be analyzed, debated, and revisited for a long time. Not because of what was said, but because of what wasn't. And that's what makes this moment so powerful. It wasn't dramatic shouting or political theater. It was quiet, controlled, and precise. A document placed on a table, a question asked once, and a silence that may end up meaning more than any answer ever could.